Hello, everyone, and welcome to Week 6, Chapters 4 and 5 of our Employment Dispute Mediation course. This week, we're going to talk about mediation preparation, preparing to mediate, and mediation is a structured process. This is Chapters 4 and 5. Now, I don't think that this material is going to be as complex as the past material that we've covered in this course or the future material, and so our lecture, I anticipate, may be shorter than the last couple of weeks. But I begin with this slide, which shows this progression of the mediation process in terms of the mediator's perspective. We talked about role conception. Now we're going to talk about planning. And role conception has a lot to do in determining the kind of planning and the extent to which planning will occur in a mediation. But we get to the question of can mediations be planned? And some mediations, it's very difficult to plan, especially those that arise in a court context, something like small claims court mediations. In those situations, mediators go to the court. They're usually volunteer and trained mediators, and they don't meet the parties until the time of the mediation. The parties appear for their small claims court trial, and as they appear ready and present, the court will often send them out into the hallway with a mediator. And in those situations, there's not really a lot of time or opportunity for planning. And that may also be the case in other kinds of community mediations or any kind of a situation where mediations occur without a lot of prior notice to the parties or to the mediator. But in many cases, there is a lot of things that go on before the mediation, and employment mediation is one of those contexts where planning can be extremely important. In employment mediation, the mediator often, and probably more often than not, receives a lot of information prior to the mediation. A lot of information about the claims of the parties, perhaps briefs, perhaps documents to review. And so there is more time that can be spent deliberately than later phases. If someone's mediating a small claims case, the first time that they're going to see documents or hear information is when the mediation starts. And so it's hard to digest that and be prepared in any significant way. It's kind of on the fly, and you're learning about the case, about the conflict, dispute, and the parties, really as the mediation is going along. So when you have this greater amount of time before, you can be more deliberate than in later phases. And also, when you're getting this information, and again, I have to emphasize in employment dispute mediation matters, the mediators often get lots of documents, lots of information. And so having that time to pour through that will allow the mediator to have a guide, so to speak, as to how to organize the material or organize the inquiry. How are the parties going to interact? And again, let me emphasize this as well. We've talked about mediations where the parties meet together or they meet in caucus. In employment dispute mediations, almost always in this area in California, and maybe in a broader context, mediations of employment matters occur in caucus or where the parties are separated. And so back to the information. You get a lot of information, and the mediator, a good mediator, is going to be well prepared. They're going to study the materials. They're going to become well acquainted with it and with the parties. And that then is going to really kind of be an insurance against oversights for issues and so forth. Because as you study documents, as you study briefs and other matters, the mediator has an opportunity to kind of outline what he or she thinks the issues are going to be. Now, again, all of this is tentative. because of the dynamic nature of mediation, planning can only be tentative. But being well prepared can also serve a greater purpose, and that is to lend dignity and respect for the process, and also serve as providing a perception of legitimacy, which is important for procedural justice. And I'll talk about that in just a minute. But remember, in almost all situations, pre-mediation plans will out of necessity be tentative and subject to testing and revision as the case unfolds. You have to be flexible and you have to be able to adjust to the circumstances. So the importance of planning procedural justice. Research, and the slide's kind of old, so when it says research is beginning to show, I think it's showing, and it's probably showed for more time than just beginning. But as stated, the research is showing that many participants value what they value in a dispute resolution process has as much to do with their sense of procedural justice. Now, I mentioned that before in that triangle, and I'm going to get to that triangle again. But people are very, very affected by how fairly they feel the process was conducted, as with other measures of satisfaction, in other words, the substance of any resolution. People that are in disputes or in conflict are particularly concerned as to whether or not they've had an opportunity to have their day in court, to have their say, to an opportunity for voice, to tell their story to a third party. And not only to tell the story to a third party, but to tell the story to a third party who listened and conducted a careful, unbiased, and dignified proceeding. If you have this proceeding planned, if you have confidence, and if it's structured well, these aspects of procedural justice needs can be satisfied. And I can't emphasize that enough. Another thing, it's not on a slide, but I'm going to say this over and over during this course. One of, if not the most important things that a mediator can do from the outset in a mediation is establish trust and rapport with the parties particularly, and also with their representatives. Establishing trust and rapport takes time. It takes effort, and planning becomes an important aspect of that. I know some employment mediators who have told me that one of the things that helps them almost more than anything else from the outset, from the beginning, is when people come into a mediation and he knows the parties. He knows their names, he knows their stories, their positions, he knows the facts, he knows what's in documents. And that, if you think about it from the perspective of a dispute in a party, this may be the first time they feel that they've been heard other than by their attorney. And quite frankly, some people don't feel that they've been fully heard by their attorney either. But in any case, this gives them the opportunity to feel as though they've had this voice. Studies also show that perceptions about process and outcomes are interrelated. Now, again, that's what I said before. When people feel that the process has been fair, then they are more likely to also feel that the outcome was fair. And sometimes that process can be as important or more important than the outcome. So very important. So having said that, let me go back to this triangle that I presented to you before. People must feel part of the process. They must feel respected, and they must feel that the other parties and the processes are trustworthy. Take for instance, an employee who has a grievance and they feel like they've been mistreated. Maybe they've been subject to retaliation. Maybe they've been passed over for a promotion that they felt that they deserved, and that it was by virtue of some discrimination. And so this becomes known to the supervisors, and unbeknownst to the employee, there's a process that ensues, and it goes up through various levels of leadership, and they talk about it, and they go over the facts, and they go over documents and so forth. And in the meantime, the employee is totally left out of this process. And maybe this process takes time. Maybe it's a large corporation. It's got to go to several levels, maybe regionally or nationally or internationally. So the employee is sitting back feeling frustrated, but really a lot of things have been happening. And it takes a long time. The employee goes to a supervisor and indicate some displeasure with the length of time that it's taking to address those concerns. And ultimately, they come back with some kind of a resolution, and they bring the employee in and announce this is what's going to happen. And the employee becomes irate. Now, the employee may not be fully irate over the substance of what was presented. The employee might resent that they were left out of the process, that they never had a chance to express their concerns. This is particularly important if people feel as though they've been discriminated against. Maybe there's, perfect explanation for what happened. And had the party been made a part of, and I realize in some cases and in many situations, there's some confidentiality and reasons why parties would not be involved in certain aspects of the process. But the point I'm making is that when people feel like they haven't really been part of a process, or at least part of a process that they've had anything to do with, they almost also may feel disrespected. And if parties feel that they have not been respected, well, the first two sides of that triangle often lead to the third, where people don't feel that either the parties or the processes are trustworthy. They must have that sense, and that's not as difficult to do as we might think. It doesn't cost money. It doesn't cost a lot of things to have a process that respects people without jeopardizing the autonomy of the company or the leadership that's involved in the employment, but providing for people to feel respected and feel part of the process without their really being empowered to manipulate or exploit. Very, very important. Now, one of the key determinants of the extent of planning is really how the case came to mediation in the first place. Mediation is often a product of a contract, or it's a part of a dispute where post event, after the event giving rise to the dispute occurred, the parties are engaged in some kind of a process, whether it be litigation or arbitration or something else, and the parties decide to submit the matter to mediation. So it could be by contract, or it could be by the parties voluntarily agreeing post-conflict to submit the matter to mediation. And when the parties have that control over the mediation by contract or by party submission, then there's more opportunity for planning, because the parties can determine what the timeline is going to be. And maybe they want the mediator to have an opportunity to read lots of documents, to go over lots of facts, maybe even to have meetings separately with the parties. And so that can be built into the process. And that may, to a large extent, determine how much planning, the extent of planning or planning at all, in terms of how the matter gets to mediation. Party submission probably provides the greatest opportunity. Now, on the other hand, if it's by court or agency appointment, and I already gave the example of small claims court, but sometimes the courts will send a matter out. It's in litigation, it's been assigned to a judge, but before the matter is going to go to trial, a particular court or state may have rules that require litigants to mediate their disputes before being allowed to get a court date for a trial. And so there may be varying timelines. Some courts may send it out with very short fuse in terms of how much time people have to mediate before it comes back to the court for further phases of the litigation process. So there might be short, there may be longer periods of time. And depending upon that length of time, and also depending upon the rules of the particular court or agency, there may or may not be pre-mediation planning. The rules might preclude meeting with the parties before, although I don't think that's often the case. But agencies may have those rules. They may also have rules about the mediator meeting what we call ex parte, or individually with parties, as opposed to both of them together. But again, that arises more in arbitrations than mediations. In mediations, it's very common for the mediator to meet with parties separately. We'll talk about some of the challenges and problems that might arise by virtue of that. Also, matters may be come to mediation by referral by other authorities. There may be administrative law proceedings where built into the statute or the regulations, there is a mediation provision. The Individuals with Disabilities Education Act, or the IDEA, what we often refer to as special education, has built into the regulations and the statute a mediation process. And then again, there may be pre-dispute mediation clauses in contracts. Again, there may be requirements of law that have mediation occur before certain other kinds of processes may be utilized. And depending upon the law or the mediation clauses in contracts, or even when a mediator initiates contact with the parties and the parties agree to mediate, all of those circumstances may have significant impact on planning, whether there is planning and the nature and extent of that pre-mediation planning. Now, we need to distinguish between two related but really important, distinct, different forms of planning. We have process planning, thinking about the possible ways of setting up the procedures and the physical environment of mediation to have the greatest chance of success. And in those situations where there are opportunities for significant pre-mediation planning, and the mediator is able to talk with the parties or their representatives and get a sense of where the parties are and the barriers that may exist to effective negotiation, whether it be emotions or cognitive biases or things of that nature. The mediator and the parties really all have a chance to think about the possible ways of setting up this procedure and the physical environment of mediation for it to have the greatest chance of success. Interestingly enough, one of the important things, where's the mediation going to occur? In special education matters, the mediations often occur at the school district site. One of the problems with that, although it may be cost effective for the state, it's really, like a home field advantage for one side over the other. And that can taint the effectiveness of a mediation. If you've got an employment dispute and an employee is making a claim against the employer, the mere fact of scheduling the mediation at the headquarters of the company or in the offices or the conference room of the president, or in the office of the supervisor, that can really taint this sense of procedural justice. So planning the physical environment is very important, and having the time to do that. Now that process planning, and I'll talk about that more in terms of thinking about who should be there, who shouldn't be there, how chairs and tables should be set up, what kind of accommodations are going to be made if you think it's going to be a lawn mediation, the planning for breaks and meals. Are you going to take a break to go out for lunch, or are you going to have someone bring it in to save time? Then another kind of planning is the problem analysis. And like I said, in employment dispute mediations, mediators are often given a lot of documents and information, which gives the mediator an opportunity to go over the material, the facts, talk to the parties, and maybe form a tentative hypothesis. But I say that with caution, because the risk of doing that is coming to premature opinions about the case. And even though really effective mediators may have tentative opinions and so forth, they're able to really control those feelings and thoughts and keep an open mind, knowing that there may be a lot more information and other things that evolve during the course of the mediation. But problem analysis can be very important. Like I said, planning, being prepared, serves so many other needs as well, particularly the needs for feeling that procedural justice has been met. So again, if you, and I think our text poses this question, that as you go through this material, ask yourself how, if at all, the way the case got to mediation might affect the sorts of planning decisions that are ultimately made by the mediator and by the parties. So here's one question. Is this case appropriate for mediation? Now, sometimes a mediator may have a case come to them or a dispute come to them where there's not a lot of information about the nature of the case. So there's certain kinds of cases that may not be appropriate for mediation. Some child custody cases, now I believe child custody cases are almost always appropriate for mediation, but when you have domestic violence cases, or when one of the parties is alleged to be an incompetent or actually a dangerous parent, there are some cases or situations under those circumstances where mediation just may not be appropriate. May not be appropriate to have mediation where where an employee or someone else in an employment context has alleged violence against them, either being sexually assaulted or harassed, where there are tremendous imbalances of power or imbalances in abilities to negotiate. So you really have to, as a mediator, think about whether or not this case is appropriate for mediation. It might be because, like I said, the parties are unable to bargain adequately, and you may not find that out until you're actually in the process, and it may become necessary to stop the mediation. There may be cognitive deficits, fear of the other side, and again, that happens in many situations where there's been violence or threats or aggression. You may also become apparent that one of the parties is seeking to use the mediation for purposes other than resolution. You know, maybe they're just trying to get information. They have no intent in bargaining, and it becomes apparent that they're asking questions, trying to get information, they're trying to intimidate, maybe they're being very aggressive in their comments. And so there's this thought that maybe this is just not an appropriate case for mediation to allow this kind of abuse to go on. There also may be a serious question regarding the authority of the parties present to resolve the matter. let's suppose that it's a claim, an employee claim against a company, and the company sends some coworker, someone down the chain from leadership to the mediation, and it becomes apparent that that person has absolutely no authority to make a decision or to commit the company or department to anything. And it's amazing how often this happens, where perhaps there's an order, the parties are ordered to mediation, or maybe there's a contractual obligation to mediate, and one of the or both of the parties, usually one of them, has no intent to be serious. They want to go to court. Maybe they're bigger, stronger, have more resources. They want to intimidate. They want to make an example of someone. Maybe it's an employee that feels that they've been so horrendously harmed by what their employer has done that they want publicity and they want to really make this a big show. Maybe they want precedent. And so you look at it and see whether or not a mediation is really being used for an appropriate purpose. Now, I say that, but I also need to caution you with respect to making those judgments, because it would not be good if you misjudged what a party was trying to do or not do. So be careful as well. And I can't, say how often, or I can't overstate how often people appear without authority. Insurance cases, maybe there's a particular kind of claim by an employee where there's insurance that would cover that, but neither the company nor the insurance company really sends anybody with any authority or with enough authority to reasonably resolve the matter. And then keep in mind, even if all the parties have expressed a willingness to mediate, is this a case where one side's unable or unwilling to negotiate in good faith or compromise at all? I mean, it may not be a matter of good faith or bad faith. It may just be a totally irrational person or party that just is not living in the world of reality and is unable to process information in a productive and objective way. There may be situations where a party holds a particular position genuinely out of genuinely held moral, religious, or other personal convictions, and nothing that happens in the mediation is going to change that. And then there are those that perhaps would personally like to resolve the case, but they may feel that for political or other reasons, they just can't accept responsibility for entering into a voluntary agreement. Now, I've seen this in education. I've seen it in employment cases. Maybe the negotiation is occurring at a regional or a local level with respect to a company, and maybe the supervisor or the manager of a particular department would really like to resolve the case, maybe feels that the matter should be resolved, the employee should be compensated, but to do so would be a career decision, because those up above who have power are not going to like it, and there are going to be repercussions if that happens. So they seek cover from a court rendering the decision as opposed to their voluntarily doing it. Next question, am I the right mediator? Now again, as I said before, and in this slide I've mentioned of a special education case and in-class discussion, and this course is taught, this mediation course is often taught in a classroom setting, and I have a discussion with students about this. And because we're not in a classroom situation where we can have a discussion, I'm going to handle it in a little bit different way. And I'm going to use a different example. I'm going to use an example of an employment case where there is allegations of discrimination or retaliation. The parties want to go to mediation. And the parties or their representatives may feel that it is very, very important to have someone with expertise in this field, maybe even a judge who has heard or presided over trials and can give the parties, an evaluation or better establish credibility with the parties in controlling the process and having an influence on the outcomes than if perhaps some mediator came in that, while a very good mediator, doesn't really know anything about employment disputes or employment dispute mediation. As an example of this, there was a 2001 study of the construction industry disputants, and mediation became very, very popular in that field as in other fields. But one of the reasons why it became important in construction industry disputes was because of the necessity of resolving these disputes quickly. You're in the middle of these huge projects, and the last thing you need is people involved in that construction project to be bogged down in disputes that affect both their relationships, their resources, and also have a great impact on the timing and the progress of the project. And so these people, the study showed that knowledge, subject matter knowledge, was one of the most important, if not most important, criterion that was used by a considerable margin of folks, both representatives and parties, in selecting a mediator, even over other attributes such as mediation experience or even legal expertise. And you will find in some contexts that subject matter knowledge and experience outweighs legal experience and expertise. And there's important reasons for that. As lawyers are often trained to think in a different way, to think about law and facts and what's going to happen in a trial, and to not deal so much with the non-legal issues, the emotional issues, or other things that may be important to the parties. And again, that study also showed that these disputants that were involved in these construction industry mediations also wanted and expected mediators with this expertise to provide an evaluation of the merits of the dispute, and forcefully if necessary. And forcefulness is necessary for a couple of reasons. I know as an attorney practicing for 40 years, for the first 20 years, I was both a mediator and also an attorney representing people in mediation. I always hated it when I, got a mediator that just was not willing to work hard. They come in and say, "What's your demand? And what are you willing to offer?" Well, it seems like you all are far apart, and the mediation ends. So often people want their arms twisted, their client's arms twisted, or the other, especially if they believe that there is a fair resolution possible if the mediator can effectuate a change or transformation in the way people think about the conflict in their particular positions that they have staked out. So as a practical matter, then neutrals with no subject matter experience are unlikely to be selected in certain technical and specialized areas. Now, while I say that, let me caution you, because many folks that are involved in mediation training, where they're getting degrees, we have lots of students that come in that have not had a lot of subject matter experience. Maybe they're law students and they decide that they're going to get an LLM, which is a master's degree for lawyers, or a master's in dispute resolution, which is a master's degree for non-lawyers. And they become discouraged when they think about the fact that people are telling them, because they have no lengthy experience as a mediator, no subject matter experience, that it's unlikely that they will be selected. There are situations where that experience can be gained, and where the ability and skills of a mediator do become important, and maybe even more important than subject matter experience. But it's hard work and it takes time, and it's something that people need to work at. And those people that become successful mediators often spend a lot of time networking and volunteering to get a lot of experience mediating different matters under their belt. Now, some mediation consumers are really intolerant of even the slightest mediator learning curve. And I would go back to the construction industry as an example of that. But again, I should say does this necessarily mean that only a specialist can successfully mediate such matters? I say not. And I don't have time to go into it to a large degree, but there was the Microsoft antitrust lawsuit that was mediated initially by a retired judge that had tons and tons and tons of antitrust subject matter knowledge and experience. And in spite of that, this particular retired judge was not all that great at mediation, especially facilitative mediation. The judge had been used to having his way, and judges, in their chambers have a lot of power. Was a mediator, that didn't go over so well. And in spite of a lot of effort and a lot of time and expense, the judge was not able to resolve that case. Later on, 2 mediators were selected, not because of their antitrust experience, but because of their skills, knowledge, and experience as mediators. And that made all the difference. Now, again, there's some other questions that we're going to talk about, and that is the issue of neutrality, whether there are conflicts, and in terms of past dealings with the party or involvement in the dispute, and disclosure issues. So let's talk about the first question: can I appear to be and in fact be neutral? And again, I'm not going to talk about these hospital religious cases that are in the book. You can read them, and I don't need to read to you, and you'll be offended, I think, if I do. But in the course of a case, we're all human and have human emotions, human experiences, and backgrounds. And so it's not uncommon for a mediator to perhaps develop sympathy or the opposite, antipathy, toward one or more of the participants. Maybe the claimant has been a victim of some sexual harassment or something, and you as a mediator have had a similar experience in your own life. And as you're getting involved in this mediation, just your own personal feelings become so strong that you really are so sympathetic to one side that you really cannot be neutral, or maybe even appear to be neutral. Now, effective neutrals become skilled at keeping their reactions under control, maybe even their feelings to a certain extent. But that can become difficult. And at some point in time, a mediator really needs to decide whether or not it is possible for them to both be neutral and unbiased, and also maintain the appearance of neutrality and being unbiased. And again, it becomes an issue of whether or not we can trust ourselves to remain neutral in the face of these strong feelings that we might have. And maybe it's not a prior experience you've had as a mediator, but maybe you just have this gut reaction to a particular person or party, and they're just not likable, or they're just not, maybe they have a very strong argument to make in favor of their position, or their position they're taking in a particular dispute, but you just have this dislike or this discomfort with this party or person. That can be problematic. Now, also, what if you've had prior dealings with a party or involvement in the dispute? And you have to keep in mind there are some ethical obligations, even in spite of the fact that there is not a lot of regulation and oversight of the mediation profession. Most of the recommended standards, and where there are standards, will say that if there's something in the mediator's past that would cause a reasonable person to question whether or not that mediator could be unbiased, neutral, and impartial, that information ought to be disclosed. And sometimes it's because there's involvement with a party, dealings with a party, and I don't mean just very insignificant dealings. I mean the fact that that the mediator may shop at the same Target department store, may have seen a party at the Target department store, does not mean that that kind of knowledge or involvement would necessarily disqualify the mediator from being a mediator in a particular case. You have to look at it in terms of the facts and think about whether or not a reasonable person would question it. Now, if you're mediating a case and in comes one of the parties who happens to be your spouse's best friend, not your friend, but your spouse's best friend, I think most people would say, yeah, that's probably problematic. Maybe you've been employed by the same company or worked in the same department. Again, what would a reasonable person think? Look at the example that they give. When the feuding co-owners of the New York Mets baseball club could not agree on a price at which one would buy out the other, who entered the fray to mediate and ultimately assist in resolving the buyout dispute? None other than Commissioner Bud Selig. Now, people would say, well, golly, there's significant involvement with the parties. The parties know them. Wouldn't that be inappropriate? And we have to understand that there are examples of mediators who not only have relationships with the parties, but also hold a stake in the outcome. Now, again, as I mentioned at the beginning of my lectures, in mediation training, you may not function officially as a mediator. You may utilize mediator skills in dealing with employees or people whom you supervise or over whom you have responsibility in connection with resolving disputes. And so you may perform mediation functions in spite of the fact that you know the parties. So it's important to keep in mind that aspect. And sometimes people will choose a mediator really because both parties do know and respect the person that's being chosen to mediate. So it all has to do with context and the circumstances. Now, the model of an authoritative mediator, and this is what I was just talking about, with some interest in the outcomes, not unusual. And again, this is a similar example. A factory manager attempting to improve the working relationship between two antagonistic subordinates. I know a situation at a college where a person that works in the Title IX office is dealing with people in conflict all the time. And before bringing a mediator in, that person will try to resolve the conflict and maybe perform some of the mediator roles in trying to do that, or use some of the strategies of a mediator in trying to do that. Think of a school principal seeking to bring about a truce between two fighting students or two fighting teachers. And again, even going up to a U.S. president trying to broker a Middle East peace accord. Now, again, the United States have great interest in that outcome. But it's not uncommon to have an authoritative mediator that does have interest. So the takeaway from that is neutrality is neither a universal concept nor a pure one, nor realistic in many situations. And that is the subject of a lot of debate as well. There are some scholars, mediation scholars, that think that they should dispose of the illusion of neutrality and just say, hey, neutrality is not one of the core values of mediation. I think it should be, but I think we have to keep in mind the limitations of that. Okay, and then again, am I the right mediator? The disclosure situations. And, consider this. In all these situations, however, any prior dealings with the participants are loyalties and affiliations that might, if discovered later, appear to conflict with the neutral's duty of impartiality must be disclosed. Now, it's been said, and I've had a number of people comment, well, if you have that kind of conflict, the parties can still waive it, and that may be true. But you got to be really careful, because even the appearance caused by an affiliation that affects the proceedings could waste a lot of money. This may be a long mediation. The parties may invest a lot of money. And if there's this appearance of the lack of impartiality or neutrality that gives an opening to someone to come back and try to set aside the agreement because of that, you really want to avoid that if you're a mediator. Now, one big question arises: should the mediator have a pre-mediation contract with the parties? And, in some cases, like those that arise in small claims court, pre-mediation contact is not feasible, and therefore having the parties sign some kind of an agreement may not, really be realistic. It may not be necessary, especially if you're doing it pro bono and you're not charging. But it is a good idea if you're in the practice of mediation, if that's your profession, or if you charge folks for mediation services. And so these pre-mediation activities that you're involved in, this pre-mediation contact with the parties. I'm talking about contracts, and I'm getting ahead of myself. Pre-mediation contracts and contact with the parties. And I've been talking about contact, but let's talk about pre-mediation contact for a moment. Like I said, sometimes pre-mediation contact is not feasible because of the way it came to the mediator. Sometimes it is feasible. Now, I'll tell you, as a practicing attorney, more than once I've become very angry at a mediator for mediating with the other side without previously letting me know, and without having a discussion about what the scope of that discussion would be. And there's a reason for that. I was once representing the husband, lost his wife in a terrible freeway collision where a big rig had fallen over on top of his wife's car, and she was killed. And we were going to the mediation, and this was a very high value case. When we arrived at the mediation, at the offices of the mediator, the insurance company representative and the defendant were already there. They were already in an office meeting with the mediator. Now, I really became very upset for a couple of reasons. The very appearance of that happening, the very appearance of having a lack of neutrality was very important, and it was upsetting to my client. And so I made a point of really going after the mediator in front of my client for two reasons. One, I wanted the mediator to apologize, to assure my client that he was still going to be neutral and unbiased. But also for another reason, I was pretty sure for the rest of that mediation, he was going to go out of his way to demonstrate to me that he was unbiased. And that, quite frankly, I have to admit, I felt like I might get the advantage of having him be biased on our side, simply by the effort he would make to prove that he had not been tainted by virtue of that pre-mediation contact. Now, in reality, good mediators will often have pre-mediation contact with the parties, but it's always a good idea to talk to the parties and explain to them what that contact will be, the purpose, what you hope to accomplish, and what the nature of that communication will be. And in these pre-mediation activities and contact with the parties, you could be gathering initial data, and you can get more information talking to a party individually rather than jointly with the parties. And there may be some things that the party may be willing to share with you that they're not willing to share with you in the presence of the other parties. On the other hand, keep in mind and don't be naive to think that just because you're meeting privately with the party, they will share with you all information, because I guarantee you they won't. It also gives the mediator an opportunity to explain the process and the mediator's role and the mediator's role orientation. So you don't have to take time out of the mediation itself to do that. Although initially in the mediation, that's an important aspect of being able to create rapport and trust with the parties. You might also have pre-mediation discussions with the parties about who's going to participate, making sure that people will be there that have authority, and also making sure that people aren't there who might be a hindrance and cause problems with respect to the mediation. And then again, talking about confidentiality and explaining both the breadth and limitations of confidentiality is important. Now, should there be a written mediation agreement? And again, if you do have one, I recommend having one, particularly if you're mediating and there's going to be compensation. It really gives you an opportunity to describe the process, the ground rules, the mediator's responsibilities. And in some cases, although I don't include this, the mediator's philosophy, because my philosophy is flexible and it depends on the context and the circumstances. So if I were to include my philosophy in the mediation agreement, I might very well be tying my hands. Again, if you're in business, you want to identify the compensation that you'll be paid and how it's going to be paid. The people, the persons or parties that are responsible for payment. You want to disclose any conflicts of interest. Make any disclosures you need to. Talk about the scope of confidentiality. When we talk about mediation confidentiality, it's not a one-size-fits-all, so it's important to have that discussion. In legal matters, the acknowledgement that a law-trained mediator, now again, when you're a lawyer and you're serving as a mediator, it's very important for lawyers to make it clear that they're not serving as a lawyer for either party, even for both parties. Sometimes there are ethical duties that need to be included in terms of the scope of confidentiality or other terms that have to be in a mediation agreement, and it's important to be aware of those. Interestingly enough, the authors threw out this other issue that sometimes arises, and that's where perhaps in a mediation agreement, a mediator tries to put in some disclaimer or waiver of liability. They ask for your reaction to that, and I'll tell you what my reaction is. I wouldn't put it in there, and I would think that if I did put it in there, that might affect the party's perception of my trustworthiness and so forth. Okay, who should and should not be present? In some cases, it's very clear who's going to be there. Of course, you need stakeholders, anybody that's important for a decision to be made. Anyone important whose input is necessary for a resolution of the claim should be there. If parties have some, agent acting in their behalf, it really needs to be clear that they're authorized to act for them. Because if you don't have anybody with authority to reach a resolution, then no real meaningful mediation can take place. Also, you need to be aware of these kinds of limitations that could occur structurally, such as language. Now, I've been in many mediations where a party does not speak English, and I would caution you against just using anybody. I've been in mediations where a school district perhaps is not remembered to get an interpreter, so they go get someone. Maybe it's a custodian or an aide or someone else that happens to speak Spanish. I didn't think much of it until I was in a mediation with a colleague, actually a former student who was native South American, spoke obviously Spanish as a first language. And when we got into the mediation, and the interpreter that was just this ad hoc person that they had pulled out of another room to mediate, to participate in the mediation as an interpreter, as they began to interpret, my colleague looked over at me and said, "Not even close." That can be very, very problematic, especially if you don't speak the language that is being interpreted, and you're either the mediator or you're the representative or agent for someone in mediation. Now, sometimes courts and agencies refuse to allow lawyers to appear, and sometimes that's for good reason, but some agencies and courts really want the parties to work out an agreement or a conflict, and so they may either not allow attorneys to appear, although I would say that's probably rare, or confine the attorneys or counsel or representatives to a non-speaking role. Who should and should not be present? If we look at the stakeholders, interested others, sometimes you may have two parties in conflict, but let's talk about a situation where there's a dispute between homeowners that live in a homeowners association over a tree that is in the common area. They're fighting it out, but ultimately the tree belongs to the homeowners association. And so if you have a mediation, you don't include the homeowners association, you're not going to be able to reach an agreement that can be enforceable because a very important stakeholder is not involved. And sometimes, when you have employment disputes and perhaps a spouse is got a claim for this or that associated with their employment, and they go to a mediation, but they don't bring their spouse with them, and you get the sense as things go on that the husband says, "Well, I'm not sure if I can agree to this. I may need to talk to my wife." Or I may need to talk to my husband, or may need to talk to my significant other partner. If you have those situations where other, and I say interested others, can have a significant influence over the outcome, whether or not there is a resolution, you have to decide whether or not it's appropriate for them to be there. Also, if you talk about a particular situation where someone without authority fails to be there, the key decision makers or the right party representatives need to be at a mediation. Nothing's more frustrating in mediation to go through this process and bring people along only to find out that the person that really has to make the decision has passed this off to someone else that does not have the authority. And there's a couple reasons why those are important. And it often happens in large membership groups or in corporations, where the more senior person really doesn't want to be bothered. So it's not that they don't want to resolve it. They just don't. They have what they believe is higher priorities. So they send someone else there that does not have the authority or capacity to reach an agreement. And not only is the mediation jeopardized by not having the right authority there, the person who should be there is also deprived of the process, of the ability to listen to the other side and to listen to the information and to be part of the process where the mediator is helping to shape how people think about conflict in the particular dispute. And maybe if the decision maker had been there, they would have been better able to change their perception or to get a better feeling for what would be appropriate or not appropriate. And so having the right people there is just extremely important, and it's an important part of that planning. Now, how should the physical setting be arranged? There's a lot of information about that. You think about how people might feel. Remember, parents typically sit at the head of the table. So if you come in and one party's sitting at the head of the table and relegating the other parties to the side, there may be this feeling that comes in that, again, remember, provokes negative feelings, the core concern status. So thinking about how the room is organized, and there's a lot of research about whether or not people are able to communicate better sitting, face to face, catty corner, or side by side. But giving thought to how the physical arrangement is set up can be very, very important. And again, here's some information about social science in that. I won't go over it. You can read it. I'm going to skip over this water purification company example. And again, different contexts might have different choices or more appropriate choices for how a room or a place for mediation is set up. There's also a lot now happening with mediating online. It's not a specialty that I have been involved in to any great extent. In fact, for a long time, I felt like mediation was so personal, it needed to happen face to face. But with technology advancing, mediation online is becoming more popular and more practical. We had actually what was called a mediation scrimmage with another university on the East Coast last year. And we had a mediation, and the folks on one side were back east and we were here at USC. And I was really skeptical about how that would happen, but we used this technology called Zoom, which we use here in this online platform, not for these lectures, but for the course. And I was really impressed with the quality and the clarity of both the video and the audio. I was used to Google Hangouts and Skype back when people were talking and the voice was a word or so behind. And in those situations, I think mediating online would be very problematic. But that is a developing process, or a developing business, if you will, and a process that is being utilized more and more. Some examples of that I've become aware of are some cities are using it for minor parking ticket matters, or some minor criminal matters. Some places are using it for collection, property tax disputes, and so forth. And so I think we're going to see more online mediation in the future. And I won't go a lot more into that. You can read about that. How formal or informal should I be as a mediator? Now, again, you can look at these particular situations. I'm simply going to say context is important. Some people expect more formality. Some people expect more informality. I tend to be more informal. That's my personality. And I also think that that gives me greater opportunity to establish trust and rapport with the parties. But when I say informal, I don't mean flippant, and I don't mean disrespectful or crude. I've seen some mediators who use foul language, and they think that's either funny or edgy or whatever. I don't condone it, and I think that in many situations it would make people feel extremely uncomfortable. Also, in using first names. Some people are comfortable with that, some people are not. And you have to be sensitive to what the parties want and what their comfort level is, and adapt accordingly. When should the mediation take place? How long will it last? Again, some people have attention spans or endurance that where it's not helpful to go for long periods of time. I've seen mediations where participants in his 90s, or she's in her 90s, and this mediator's going on for 5 hours, and I'm looking and saying, we might have other problems if we don't take a break or stop this. So you have to think about when the mediation should take place and how long it will last, whether or not it's going to be in one session or multiple sessions. And also, again, the circumstances might have a lot to do with that too. You may end up going longer in a particular day, especially if you have one of the parties that's flown in from out of state and they need to get back, and some travel arrangements may dictate how long you go at a particular time. But we need to be careful about people getting their endurance, their fatigue, because that can in and of itself be a cause for impasse. Getting the timing right can greatly enhance, again, the chances of achieving a resolution. That's part of this planning, part of this thinking, and making sure that you allocate sufficient time, because failing to do that is at the root of many mediation failures. Anticipating and analyzing the problem. Now, let's talk about this. I talked about it previously for a few minutes, but let me revisit it here. Analyzing the problem. These substantive preparations. How much preparation should occur? And again, I'm going to say this, that in employment dispute mediations, the mediators often receive a lot of information, a lot of documents and briefs. And the parties most often want the mediator to have that information. And as a result of that, the mediator will try to form some tentative hypothesis about the dispute. In legal matters, it might focus on legal issues, how the facts are applied to the law. It may have something to do with evidentiary or procedural dimensions. Maybe there's an argument that the statute of limitations has passed and the claim that a party is making is untimely. But in any situation where a mediator tries to form tentative hypothesis, the mediator is going to spend their time well if they try to look at identifying possible barriers to resolution. Now, again, you're trying to form a hypothesis based on what information you have, and it needs to be tentative. But sometimes you can get clues as to the emotions or to the hot buttons of one party or the other, those core concerns. And so you need to be able to look at that and try to create a hypothesis, but make sure it's flexible. This advanced analysis is aimed at having really a leg up on these areas of information that may be very important and fruitful. And it may then provide a framework for further questioning and further topics to explore. But that degree of preparation is obviously not going to be possible in every case. And in many cases, it may not even be desirable. Depends on the context. And keep in mind, too, that some mediation programs, including those with courts or organizations, might have rules that actually preclude this kind of preparation. I don't think that is, I think that's the exception. I don't think it happens. But we do need to keep in mind that we all do make judgments based on limited information. Remember, we can learn ourselves from those cognitive biases that so often influence people in how they interpret, view conflict. Okay, again, there are different contexts that I've already talked about before. Small claims mediation is one of them. Preparation is not going to be possible in those situations, nor is it really going to be feasible or appropriate. And again, when you look at this information, it's beforehand. When you look at the documents, when you look at evidence, to think that you'd be able to do that without speculating or formulating some opinions or questions is just totally unrealistic. So you have to remember that balancing the information that you get with the ability to remain open and not get to a point where you cannot be objective and unbiased or impartial in making and being the mediator for a particular dispute. Okay, there are also situations where it may be appropriate for co-mediation. Now, I said that this wasn't going to be as long of a lecture. I apologize, I've already exceeded the others. Just goes to tell you that I'm not very good at estimating time, but hopefully the time has been well worth it. Should the case be co-mediated? You know, sometimes it's important to have more than one mediator. Perhaps there are cultural issues, there are gender issues. Maybe there's the need to have some legal expertise and some subject matter expertise. Sometimes in child custody cases, you'll have a psychologist or a therapist and a lawyer. Sometimes you may have experts in employment dispute mediations where you have the same combination of either a lawyer, subject matter expertise, or maybe gender or maybe cultural balances that occur by having this co-mediation model. Sometimes that's important for training as well. You may have one mediator that's more experienced than one that is getting experience. When there is co-mediation, you got to make sure that you are able to co-mediate in a productive way, making sure that you can work in sync and that it does not become dysfunctional. Nothing is worse than co-mediation partnership where it is dysfunctional. That becomes problematic. Now we talk about mediation as a structured process. And you know, I'll say on one side, yes, structure is important. It provides a framework. It provides credibility. It provides a sense of authoritativeness. That's not the right word. A sense of what I'm really looking for, the word is legitimacy, a sense of legitimacy when there is some structure. But by the same hand, it has to be flexible. a process that's well organized can provide comfort to participants and also for mediators and people that are representatives in mediation. There tends to be a tradition of what is expected in the mediation process. What happens first? What comes next? And when you have that structure, at least as a framework to work with, then it allows people not to be anxious about what's happening next. So again, procedural justice and the ability of people to feel like they're engaged in a process that's meaningful is a result of having this structured process. Now, I'm not going to use this age and gender discrimination case, but I do want to point out these lessons that come from that discussion. And these are some points or some takeaways with respect to thinking about the structure of mediation. First of all, successful de-escalation of conflict requires time. So when you're involved and you have this structure of mediation, sometimes parties try to prematurely jump from one phase to the other. They want to just get from the opening pleasantries and get right into negotiating. And if they haven't taken the time necessary to de-escalate the conflict, to deal with the people issues or the emotional issues, it's going to backfire. So people have to traverse those emotional and behavioral stages in order to reach a resolution, and I promise you, shortcutting it will backfire. You also have to allow for the strategic stages of competitive negotiation. Those people that competitively negotiate, where there are, we call it the negotiation dance. Someone makes an offer, someone makes a counter proposal, and it goes back and forth. And sometimes it almost seems ridiculous. Someone starts at this high $100,000, and the offer is $10,000, and then it's $96,000, and it's $14,000, and it's $95,000, and at some point in time, people go, "Are you kidding me? Can't we just get to the bottom line and reach an agreement?" Let me promise you, no. The second, the party that's at 96 goes, I'm just going to get down to where I think it's reasonable, and so I'm going to say my demand is $50,000. And now the person that just made an offer of $15,000, you've made this huge jump, and that person goes from 15 to 15,500. Now you're starting from two positions, and in the end, you're never going to get anywhere near the dollars you thought you were going to get because you tried to short circuit the dance. Cannot be done. Now, that doesn't mean every negotiation has to go in such small amounts of concessions that it's ridiculous, although some appear that way. Now, again, let me point out that structured approach can enhance the perception of procedural justice and mediator impartiality. I'll just say that over and over and over again, even though it has to be flexible. It's also crucial to widening and deepening the information flow. When you have this structure, and this will become more apparent when we talk in our next lecture about gathering information, this structure allows for things to happen. Emotions are hopefully calm. People have time to really process what's happening in terms of concessions that are being made. Perhaps they have greater time to evaluate their positions and the information that's being provided by other parties. And again, just the very trappings of ceremony can aid the settlement effort. Again, it adds to this feeling or this perception of legitimacy. So all important aspects. So here basically is the structure, and as we go through the course, we're gonna handle it stage by stage or phase by phase. Although I will emphasize continually that not all mediations happen in this organized progressive structure model. Some of them go in different directions. And while it does take time to do all these things that I just mentioned that were so important, it is not always as clean and nice as is laid out in these stages. Let's talk about it. Opening the process and developing information. That's stage one. The mediator will give an opening, and that's the subject of our next discussion. And then there's a methodology for developing information. And stage two, we're going to expand on that information base. We're going to identify issues. We're going to distinguish between mediable or negotiable issues and the broader scope of topics that people might discuss in the mediation. And after identifying things that need to be negotiated, we're going to organize an agenda, and we're going to prioritize that agenda in terms of how the issues are going to be discussed. Only after that's done are we then going to get into the problem solving and persuasion, where we actually try to problem solve. And then the last stage is dealing with impasse, because no matter how good mediators are, they're always going to end up in some mediations where there is impasse. And so we're going to talk about how to deal with impasse and the appropriate way to close a mediation. Again, I'll emphasize that there are limits of a model structure. Emotions may run so high, or strategic maneuvering may be so pronounced, that it will challenge even the best attempts to impose structure on the process. Stages can repeat themselves. You might go through information gathering, you might get so far as to actually be in problem solving, and then find out you're going back and expanding the information base. So you have to be aware of that too. Also, one stage might not be fully finished in the mediator's mind when another is begun by the participants. Now again, and what often happens is the mediator is trying to flesh out information and identify issues, and suddenly the parties are trying to solve the problem. So again, the mediator's got to be able to multitask and be able to think about the functions of more than one phase at a time, and actually think about why certain things are happening in the mediation at the time that they're happening. Again, the mediator must react while he or she orchestrates, and both lead and follow at the same time. All very, very important. Some mediations are multi-session events. So again, in the Microsoft case, it took place over months and months, actually. Eventually, before it got settled, it was years. And so you've got to be flexible, and you've got to react to certain circumstances and events that happen. And an effective mediator needs to be able to develop the ability to adapt quickly to those situations. That is the end of our lecture for today, and while I thought it was going to be the shortest, it has been the longest. I apologize for that, but hope it was worthwhile. Thank you, have a good week, and look forward to seeing you soon.